estate. You can get a hold of Thinking Real Estate at thinkingrealestate.com. That's a lot of thinking real
It
estate.
is a lot of thinking. But people think all the time. I find the word think
They
in
try.
a lot of sentences.
They try.
I'm thinking about. So if you're thinking about real estate, you ought to be calling.
Laura Dwyer-Schlecki is the Chief Executive Officer.
That's exactly right.
Okay.
Jackie's the Chief Financial Officer.
Jackie
Is that
Austin,
what you call her?
Chief
Chief
Financial
Operating. Oh, COO.
Chief Operating Officer. Who else is on that staff?
I'm the janitor.
Yes, that's exactly.
That's
Well,
Bill.
no,
I clean
I
up
don't think
all
so.
the
I think
messes.
I'm cleaning up after you.
No, I clean up all the messes, Greg.
Just any legal, but we don't have messes.
Thank goodness.
Just doesn't happen.
Well, you did last time you were here. Your dog was gone.
Oh yeah.
Yeah. You got the dog back.
The dog got
It was
gone
a
twice.
happy
Yeah,
story.
yeah. It is a happy ending.
Yeah, very much so. And she gave the shout out last week to Lisa Morency and her daughter Grace for taking such good care of our dog. So another one to them. We
And the
really
animal
appreciate
shelter.
it. And the animal shelter.
So,
Who else is on your staff?
Mary McDonald.
Okay.
She's awesome. She's probably not listening because she's working. Although I would allow live stream of your show and Mark Daly's show, but at that point it's got to be turned off
That's
after
it.
that.
That's it.
And then Jeff Fraunfelker too.
Oh yeah, Jeff
is also
Fraunfelker.
on the staff.
Okay.
All right, so what are
Okay.
we talking about today?
Don't you have another realtor?
Oh, Mark Meyer.
Yeah.
He's my partner.
Okay.
He was in early today when I was coming back from exercise, which was before 8. He was pulling in.
8. That's pretty late.
Yeah, I concur.
For Mark, that was early.
Oh, was it?
Yeah.
Okay.
So shout out to Mark.
Hey, Mark.
So what do you want to talk about?
I am yours.
Oh, that's what I thought. Okay, so I have a client who is inherited some money, and it's being held in a trust. She's buying a house. How does that all work? And the money's coming from the trust, so how does that all work?
It depends upon the trust instrument and what it says and what authority the trustee has to make disbursements to the beneficiary. Your client is the beneficiary of the trust. So she needs to, and her lawyer needs to look at what the trust actually says. The trustor is the person who set up the trust, whether that was a parent or an uncle, whoever it was that set up the trust, put in provisions for distribution of the income of the trust and the corpus or the body of the trust, the principal of the trust. So you look at that language, and if it's a support trust, then the trustee has the power to pay out income and then invade the principal of the trust for the benefit of the beneficiary. And again, you have to find out from the trust language itself exactly how much flexibility the trustee has. And if there is that flexibility within the trust language, sometimes then what happens is the trustee does not act in accordance with the trust provisions themselves, and so the beneficiary has to bring an action against the trustee to seek distribution of the funds. A good example, I'm involved in a...
Well, why would you have a trustee if they don't abide by the trust?
Well, I've been involved in litigation with trusts over the 41 years of practice, and I have a huge case going in Illinois between family members, 2 of whom are trustees of a trust of which the 6 of them are all beneficiaries. This lawsuit's been going on since 2010.
Yeah, that's ugly.
Yeah, it's worse than ugly. It's really worse than ugly. And we go to trial probably next month. We're waiting for the final word from the judge on this one. But the claim of the 4 siblings against the 2 siblings is that the 2 siblings have not acted in accordance with the trust language, refused to make distributions, and in fact, the allegation is that the trustees themselves are invading the trust for their own purposes. I won't get into the specifics, but it's typical of those kinds of disputes.
Right.
And if the parents who set up these trusts had known that this dispute was going to happen, they'd be rolling over in their graves right now.
So
This
do you
is
think it's
exactly what
better-
they were trying to avoid, and they didn't. And part of the problem is that you have trustees who are also beneficiaries with other beneficiaries. So they have an immediate conflict of interest. The best thing is to have a trustee who does not have an economic interest in the trust itself. But even then,
What,
you
like
know,
a financial advisor?
the problem with just having
Even a
been
relative would be tricky, wouldn't it?
Yes, here's what I don't do a lot of trust and estate work. I'm
Right.
associated with a firm that actually is a trust and estate firm, and they do all the setting up of that stuff. I just get involved in the ugly end of it when people are litigating. And my view as a litigator is that the best way to have a trustee, or best trustees, are co-trustees, one of which is a financial institution or advisor, the bank, some other investment firm, etc., and then a relative, because then you get the best of both worlds. You get
Well, what about
one
an attorney?
trustee, the problem as an attorney is that you're representing the trust or the trustee as an attorney. I would never presume to act as a trustee other than if it was a trust for one of my kids or some other relative, because my function as an attorney can get in the way of my function as a trustee. They're different roles. And so I think it's a bad idea having an attorney as a trustee to manage the funds and then also distribute them, because if there is a dispute, now I as the attorney can't really represent the trust. At least I don't think you can. You might be able to ethically, but you know, the old adage is a lawyer who represents herself as a fool for a client. And so now you've got to get somebody else. So I think it's bad practice. So you've got a co-trustee.
Well, and does an attorney, well, wait a second, does an attorney necessarily have the financial background to act as someone
No, that's-
distributing, thank you, the funds?
No, and then that was where I was headed, is the attorney also does not have, or typically does not have the expertise to be able to manage the funds in a manner that a financial advisor or a bank with its
Or
own
could you have a CPA?
investment department would do it. Again, CPA is a numbers cruncher. CPA is not an investment advisor. So I want somebody that's able to manage the funds, and that's why I would also have a co-trustee that is a relative who knows the beneficiary and knows what the needs are and is not hostile to it. You know, there's always or often sibling rivalry. So brothers and sisters as trustees, my experience is, don't make the best trustees. You know, an aunt and uncle, obviously parents make good trustees because they're usually the trustor, but somebody who knows the beneficiary,
But if
so
the
you get the
parent
best of both worlds.
Gave the money and the parents
Yeah, parents
deceased.
now deceased, right.
Right, which is usually the case.
Not always the case. Sometimes they set up trusts for simply estate planning purposes, and they're still alive. They're simply putting this stuff in trust in order to minimize the estate taxes that will be incurred upon their death.
So if my mother left me money in a trust, and I'm 54 years old, and
You don't look it, by the way. You
Oh.
look much younger.
Thank you. On the radio, I can look as young as my
Right.
voice,
All right.
actually.
So okay. So your mother sets up a trust for you.
So my mother sets up a trust for me. My mother passes away. An attorney handles it. I want to buy a house, but the money isn't. But the attorney determines that I shouldn't buy the house. What do I do? What remedies do I
As
have?
the beneficiary, you have the ability to sue the trustee, to compel the trustee to act in accordance with the provisions of the trust instrument.
And if the trust instrument says I can't buy a house with the funds, then he's acting. And
That's
I
correct.
mean, I don't know if
The trustee wouldn't
but-
say something like that. It's
Okay.
probably a support trust, and the trustee has discretion to be able to distribute not only income but also the corpus or principal of the trust in order to provide the beneficiary with necessities, and in fact more than simply necessities, those things that will provide comfort to the beneficiary. Again, you've got to look at the language, see how broad it is, but most support trusts would allow for that, and buying a house would typically be within the purview of the provisions of the trust. For an attorney to come in and say to the beneficiary, well, you can't buy that house as opposed to this other house, the trustee ought to have a pretty good reason why that is. Maybe it's the expense.
Can you empty the trust?
The trustee actually could do that. It depends upon how much is in the trust and what the needs of the beneficiary are. You know, beneficiaries involved in an accident or develop some disease or other malady, you know, you're going to dip into the trust and it may be completely depleted by virtue of the needs of the beneficiary. Just depends on how much is there and what the needs of the beneficiary are. And
Now, as
now,
a realtor-
now let me also tell you that there's another kind of trust called a spendthrift trust, which is a trust set up, again, typically by parents who think that their children, first of all, when they're minors, they can't get at the funds themselves. So a spendthrift trust will always say that you don't get the money until you reach the age of majority, which is 18 in the state of Michigan. And then some parents think that their children are not fiscally responsible, so the provisions of the trust parcel it out over a period of time so that the ultimate distribution may not be until they're 40 or 45 or even 50 years old. And that's a spendthrift trust. The beneficiary can't get at more than a prescribed amount of the principal. Typically, the interest is distributable. They typically can't get at more than 5% of the principal.
Do you see lawsuits against those?
Yeah, spendthrift trust particularly because the beneficiary who's 30 or 35 years old is sitting there and they want the cash. Sure, you mean
So they can spend it.
Well, sure, I got a trip to Vegas planned, and I need money to be able to,
Right.
spend. But that's the purpose of a spendthrift trust, is to manage the money for a beneficiary who the trustor thinks is not particularly capable of handling that amount of cash. in
Now, if
the lump
someone
sum.
comes to me and wants to buy a house and the money's coming from a trust, as a realtor, should I look at that document? Should I do as a realtor? Should I be talking to the trustee should I ask the buyer, who would be my client, who the trustee is, and talk directly with the trustee to make sure that, one, I'm not wasting my time, two, I'm not wasting the client's time if they can't buy a house by virtue of the language of the trust?
Yeah, absolutely. The trustee is going to require that you get written consent from the beneficiary, but it's to everybody's interest that you, as a realtor for the buyer, talk to the trustee, because that's where the funds are coming from to be able to pay the down payment or maybe the entire purchase price. And so you need to talk to the trustee to coordinate, if nothing else, timing. You may want to verify that in fact these funds are going to be coming, that it's not contingent upon some determination by the trustee that they've already made the decision that the trustee is going to distribute the funds. So now you're simply, it's timing. Usually there wouldn't be any difficulty in getting the funds from the trust, although remember, the funds are invested in some kind of instrument or other investment, so there may be a period of time that they have to liquidate the amount necessary to make the payment.
So now my trustee says I can buy a house. I have a home inspection. Home inspection pulls up a few things, but the house is perfect for me. I think it's a fair price as a buyer. And the attorney says, I don't want you to buy that house because of these issues on the home inspection. What are
The attorney or the trustee?
Well, the attorney slash trustee.
I want to differentiate.
Okay, let's say.
Hold on.
Why would they have anything to do with it?
Take the attorney out of the equation. The attorney isn't making the decision. It's up to the trustee.
Okay.
And the trustee has to have, if the trust provides for funds to be paid to the beneficiary to buy the house, and the determination by the trustee has been that yes, you can do this, yes, here's the amount that can be distributed out of the trust. Now the trustee is going to have a good reason why the trustee is saying to the beneficiary, no, you cannot buy that house. And it may be, if there are significant defects or material defects in the property, remember that the trustee does have a responsibility to provide for the support of the beneficiary and makes the determination that the beneficiary is not acting in the beneficiary's own interest. The trustee probably has the discretion to do that, but the issue is going to be, did the trustee exercise the discretion with a rational basis for making that decision? If the beneficiary doesn't like the decision, they're going to have to take them to court to be able to get a resolution of it.
And how long would that be? How long would that take to take someone to court?
Way too long.
Okay.
Look, I'm doing this case in Illinois. We started in 2010. The death of the last parent, the mother who was the last parent to die, was August 31, 2009.
Okay, so now I have an attorney reviewing everything, and the attorney doesn't like the home inspection. What is the attorney's role in all this?
Well,
Well, let me tell you what I think the attorney's role